Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Naomi Comfort. And Naomi is an attorney with the Silicon Valley Elder Law Group, PC, Professional Corporation. And I've had Naomi as a guest on the show several times before, a good friend. She's taught continuing education classes in fiduciary income taxation and other subjects for CPAs. Naomi and I have done seminars together, even talking about handling retirement accounts after a death. She's also given presentations for the public, and we've done that together. So anyway, so I'm really glad to have Naomi here as my guest today. Thanks for joining me, Naomi.
Thanks for having me, Mike.
Okay. So today, Naomi and I are going to be talking about special needs trusts. So this is sort of a specialized area. Doesn't apply to everybody, but everybody, I think, could be helpful to have this sort of information because you may know somebody, and to know where to go for help and that sort of thing can be helpful for you. So as we get started in talking about special needs trusts, I just want to caution as usual that we're covering a few highlights of a complex legal area. They have whole seminars on this for attorneys, probably classes, and so to think that we're going to cover it in a few minutes just isn't realistic. On the other hand, we just want to provide an introduction for you that will be a part of a continuing conversation with your own attorney. Right?
Very good.
Okay. So thanks again. Let's get started. Naomi, first question. What are special needs trusts, and what do our viewers need to know about them?
A special needs trust is a type of trust that is used to allow somebody to give money or leave money or assets to somebody who is disabled or incapacitated. And it's a way to leave the assets in a way that the assets are protected from the beneficiary's misuse or mishandling of the assets. And it's also a way to provide for somebody else to manage the assets and make sure that they're appropriately utilized. And the biggest piece is to make sure that the disabled or incompetent person's access to needs-based public benefits is not interrupted. So they're a very, very, very important tool. If you give a gift of money to somebody who's on needs-based public benefits, such as Medi-Cal or SSI, there can be a disruption in their benefits, and that disruption can sometimes be quite catastrophic if we're talking about a large gift. It's not just a matter of, oh, they didn't get their full SSI payment this month. They could lose their HUD housing because they no longer qualify because they have too many assets or too much income for that month. Waiting lists for HUD housing are years long. It can be very difficult to get back into their housing. They can lose their work program that is tied to their other benefits that they are maybe doing through a day program that they're involved in. They could be involved in support groups and support networks that are basically run through county organizations, and if they lose their benefits, it's not just a matter of a few dollars that they've lost because of a mistake of giving them money. It's actually their whole world basically can collapse.
Wow. Now, so in a sense we're saying, how can you give assets without really giving assets? So that they're not considered as owning those assets.
Exactly. That's what we're doing. We're putting the assets into this trust that has special language in it that's been blessed by the county agencies and by the IRS and by Congress and by the state governments. Allows us to take assets and put them aside. They're used solely for the benefit of the disabled person, but when the disabled person is filling out, or somebody on their behalf is filling out the paperwork that shows what their assets are, these assets are not counted. If they're in a special needs trust, they're not counted. So the person still qualifies for those needs-based benefits.
Okay. So how does a parent set up one of these trusts, for example, for a disabled child?
There are a couple ways they can do that. First of all, families with kids typically will go and get their basic estate planning done. They'll get a trust, hopefully, and wills and powers of attorney and advanced health care directive done as a package with their attorney. Hopefully their attorney has asked probing enough questions to find out, aha, there is a disabled child that we need to consider. And I want to use, when I'm talking about special needs trust, I'm going to use a really broadly talk about disabled people, because we might set up a special needs trust for somebody who we think might be deemed disabled sometime in the future, but is too young for us to know for certain. So we might set up a trust that could toggle back and forth between being a special needs trust and just a protective trust. So the question was, how does somebody set one of these up? First, it can be part of your living trust, in which case it says that when both parents have passed away and the assets are, for example, we'll divide it into 3 equal shares for the children, the 2 well children will get their shares outright, or at a certain age will get theirs outright. But the disabled child's share will be set aside in a special needs trust, and the terms of that trust are actually contained within the living trust that the parents have set up. That is the most common situation that we have. Most estate planning attorneys are savvy enough to ask the questions and get underneath, get to the information of, yes, there is somebody who's disabled who's going to be a beneficiary of these funds, and we need to set up a special needs trust. All of our drafting programs have basic language for special needs trusts. The other option for setting up a special needs trust, and I generally prefer to use this option, is that you draft a separate standalone special needs trust that's its own document instead of being within the parent's document. Because when mom and dad pass away, the rest of that trust is irrelevant after the assets have been distributed. And what's going to be left ongoing is that special needs trust. It's going to go on for the lifetime of the beneficiary, and it's much easier for the trustee of that trust to just have one complete document that only deals with the special needs trusts, the terms of that trust, how and when they can make distributions, and all the rules about the trust. It's a very complicated trust, and so it is helpful to have it set aside as a separate document. So those are the 2 different mechanisms that we use. We definitely do not advocate any outright bequests or having a joint tenancy or having their name on something, because it can really disrupt, again, the benefits.
Mm-hmm. So one thing that I have seen, this is not one of the particular questions that we have here, but legal awards. So for example, malpractice awards from hospitals, that sort of thing.
Oh, the bad baby case.
Yeah,
or
whatever. Well, I don't like to call them bad baby, but they have some sort of injury that happened during childbirth. Anyway, sometimes there are large awards that are made for that, and then I guess the attorneys together with the court sort of forms a special needs trust on behalf of the child.
Correct. That's a different type of special needs trust. That is called I call it a D4A trust because that's the code provision that it comes from. It's a litigation special needs trust. It's set up with proceeds from litigation. Those assets actually belong to the disabled person, as opposed to the gift or the inheritance or the money coming from the kids. The litigation or D4A special needs trust has different provisions in it. It's much more restrictive, and it also has a provision that says that when the beneficiary dies, if there is any money left in that trust, the state can make a claim on what's left and get reimbursed for the costs of all the services that they have provided throughout the years. Now, my personal politics, I don't have a problem with that. I think that it's personally, I think it's appropriate that the state can get reimbursed for the costs that they've advanced. But I think it's also very appropriate to set aside these lump sums that are available to be used to make the beneficiary's life a better life. Because really, when you're on public benefits, you're quite impoverished. And these funds can be used to buy special equipment, special services, to pay for vacations. We use them to even pay for the companion that needs to go with the person on the vacation, because a lot of our beneficiaries cannot travel alone. They're not safe to travel alone. They have to have a companion. So the companion's costs of travel are paid for also, whether that's a family member or whether it's somebody right out of, you know, the home where they're living, which happens a lot.
Okay. Now, does the child have to be disabled? What if the child becomes healthy later or something like that? Then what happens?
You know, we deal with that more often than you'd think. A lot of times I have parents coming in who have young children or younger children, and they're autistic, but highly functioning autistic. And it's really too early to say whether they will be qualified as disabled when they reach maturity. And the parents, of course, are quite optimistic because they've fought very hard for, you know, great programs for their kids and lots of special assistance, and their kids are doing really well, but there's just no way to know for sure. So when we set up this trust, we set it up so that it can toggle back and forth between being a protective trust that just takes care of the assets and manages them for the beneficiary, or if the beneficiary is or becomes disabled, then a stricter set of rules steps in, and the trustee is limited on how they can make distributions so that the person will still qualify for public benefits. And sometimes we do a mix of a little bit of both, because sometimes what somebody can get through public benefits may not be as good as what we can provide for out of the funds from the Special Needs Trust. Most common example is housing here in the Bay Area. So the amount of funds allocated to housing from SSI is $300 or $400. I mean, it's nothing. When I use the Special Needs Trust to pay for housing, it eliminates that $300 or $400 from their SSI payment. But that's the most it can eliminate. Even if I pay $2,000 a month from the trust for that person's housing, all it does is eliminate $300 or whatever the exact number is from that person's SSI. They still get their SSI, they still qualify for Medi-Cal, and I can get them a much more appropriate living situation, still getting the benefits they need for the other services, but get them a much better place to live, and still use the Special Needs Trust for them.
Okay.
I'm sorry, I'm going to bring up another one. I'm talking, I brought up the example of autistic children. Even, I think, more difficult are children or young adults who've been diagnosed with a mental illness. Because, as you know, oftentimes people with mental illnesses don't appreciate the fact that they have mental illnesses, so it can be very difficult to keep them medicated. And potentially medicated, they're fine and functioning well. Then they stop taking their meds. And then they spiral down into another episode of mental illness, whether that be schizophrenia, manic depression, you name it. It could be any mental illness, and then they become incapacitated again. So you could have a situation there where you're using that language in the trust that lets you toggle back and forth. When the person is doing well, we operate one way. When the person has been hospitalized under a 72-hour hold, and then that's progressed to the 14 days, and you know they're not getting better as quickly, and it's going to be a year or an 18-month, we hope, recovery back to where they were before. We're going to toggle that back to, you know, using the public benefits again to preserve some of those assets so that they'll last longer. to take care of the person.
Okay.